Welcome, everybody. We've got folks tuning in all the way from Hawaii to North Carolina, New York, California. That's great. And where else? And Virginia. Well, welcome, everybody. We're going to get started now. My name is Sarah Levin. I am the program coordinator for Jews for a Secular Democracy, which is an initiative of Society for Humanistic Judaism. Jews for a Secular Democracy is galvanizing the Jewish community to separation of church and state. If this is your first time joining us, welcome. And I will be dropping in the chat later on where you can sign up to volunteer and join volunteers across the country who are advocating from the Jewish perspective and voice for separation of church and state. And I'm really, really excited to introduce my friend and colleague, Nick Little, who is the Vice President and General Counsel at Center for Inquiry. He's going to be talking to us about an upcoming Supreme Court case called Fulton versus Philadelphia, which has to do with adoption and foster care and religiously based discrimination. And he'll go into more detail about the case and why and how it could have major implications for the separation of church and state. So Nick is as I mentioned, he's Vice President General Counsel of Center for Inquiry. In that role, he oversees both the center's in-house legal work and its outside litigation. He's been with CFI since 2013 when he joined as legal director, and he's worked for the recognition of secular celebrants across the country, as well as submitted amicus briefs on CFI's behalf to the Supreme Court in cases including Hobby Lobby versus Burwell, which we've talked about a lot through our webinar series, and I'm sure will come up today. Obergefell versus Hodges, Whole Women's Health versus Cole, Zubik v. Burwell, and Trinity Lutheran versus Pauley. If you follow our programming and church-state separation cases in general, these are really major church-state cases that Nick has been involved in. So you're in good hands with his expertise. And he's also filed briefs as well in circuit and district court cases. He supervised CFI's Florida litigation and is currently examining multiple possibilities for further action to protect secular humanist values and skeptical pro-science positions. Nick has involved himself in multiple local situations where the separation of church and state has been threatened. He's also worked closely with Michael Dodora and CFI's Office of Public Policy on lobbying matters, as well as providing advice on asylum issues related to CFI's work with threatened bloggers in Bangladesh and across the world who are persecuted for their non-belief and free expression. So without further ado, I'm going to turn it over to Nick, and I'll just remind you all to please put your questions in the chat. We'll have plenty of time for Q&A after. And with that, go ahead, Nick.
Well, thank you, Sarah. Great to be here. I'm going to move a presentation, and please shout at me if this isn't running properly. Okay, there we are. I very much appreciate being here. Generally, I never know quite how aware people are of what my organization is. So the Center for Inquiry, I'll be very brief. It's made up of three specific parts. First, the Council for Secular Humanism. This is our church-state separation wing, publishes the magazine Free Inquiry. Then we have the Committee for Skeptical Inquiry, which is the anti-pseudoscience part of it, publishes the magazine Skeptical Inquirer. This is our UFO and Bigfoot and also alternative medicine and all that side of things. And then we have the Richard Dawkins Foundation for Reason and Science. To sum up CFI in general, what we seek, we strive to foster a secular society based on reason, science, freedom of inquiry, and humanist values, which means we cross over in our goals very well with you as an organization on this. So I've been asked here to talk about the Supreme Court case of Fulton versus the city of Philadelphia. And as Sarah mentioned, this is a case regarding fostering of children in Philadelphia, and Philadelphia contracting out some of its responsibilities there, and the Catholic Church essentially not wanting to obey the standard requirements of non-discrimination that go on in this. But this isn't a case that exists completely on its own. This doesn't exist in a vacuum. What we need to look at first is the general area of church-state separation and where we are on this. If you've heard any of the presentations this group has put on, any of the seminars, you know this is not a good time for church-state separation. We are facing certainly the most hostile Supreme Court and most hostile federal court system all the way down in living memory when it comes to church-state separation matters. And in particular, we've had a series of decisions recently that have fundamentally readdressed the core of the Constitution in America, the First Amendment, the notion that on the one hand, there is religious freedom, but on the other hand, there is complete separation of church and state. And Sarah was right that we're going to talk about Hobby Lobby today. And if you remember Hobby Lobby, this was a case where a for-profit corporation, Hobby Lobby stores, a chain of art supply stores across the country, decided that it violated their religious principles to provide health insurance that included contraception for women as required under the Affordable Care Act. And well, the case went all the way to the Supreme Court, and Justice Alito, who is my personal nemesis, Justice Alito wrote what I think of as one of the worst decisions in Supreme Court history. It's up there in its misuse of the law and misuse of Constitution with all the classics, the Dred Scott decisions, the Plessy versus Ferguson, all these terrible Supreme Court decisions. And just like those, it had no real basis in law or history. It was instead an attempt by a Supreme Court justice to impose his personal morality on the country. And what happened? Well, we have, for the first time ever, we have this notion that a for-profit company can have religious freedom rights. I don't know. I mean, maybe when I see General Electric in the parking lot before church on a Sunday or temple on a Saturday, I'll believe this. But the notion that a for-profit company can be religious is kind of out there. Then more recently, we've had American Legion versus the American Humanist Association. This case brought by our colleagues over at AHA regarding a war memorial in Bladensburg, Maryland, a First World War memorial that is a 40-foot concrete Latin cross. And it's on public property and it's maintained at public expense. And the Supreme Court turned around and determined in this, somehow, that a 40-foot concrete cross in the middle of a traffic circle is not sufficiently religious to count as a religious symbol. Again, I have no idea how anyone can decide that way, but they did. Then Espinoza versus Montana Department of Revenue. So we had a previous case, which was Trinity Lutheran, where the Supreme Court decided that a state couldn't exclude a group from public funding for a play area just because that was a church. Espinoza took this way further. Montana had a school voucher program, and Montana decided that under its state constitution, it would be unconstitutional to include religious schools. So instead, what they did is they canceled the entire program. Various people sued, and the Supreme Court decided that Montana was not allowed to cancel the whole program. It had to reinstate the program and include religious schools. And then finally, in this parade of horribles, we had last year the case of Our Lady of Guadalupe School versus Morrissey Barrow, and another case on the same day with the same idea. Under this, religious schools, in particular Catholic schools, claimed that their teachers were ministers of the faith, and so no government regulations could apply to their hiring and firing. And they got away with this. And this case dealt with a female teacher who developed breast cancer and went and told her employer, the Catholic school, that she had breast cancer and was going to be going in for treatment. And they fired her as a result. And she has, according to the Supreme Court, no right to sue under the Americans with Disabilities Act, any of the civil rights laws. So what we've seen is a Supreme Court willing to set up a system of exceptions and exemptions. The idea that simply because you're a religious group or a religious individual, or even as we saw with Hobby Lobby, you're in some way a religious company, you don't have to obey the laws that everyone else obeys. Now, this to me is a fundamental problem, because what we're seeing here, the absolute basis of secular society that the American Constitution was meant to enshrine is this notion of the rule of law and equality for all people under the law. So we've always had a degree of tension here. There's always been people who want to say, well, the law applies, but I deserve an exemption. Generally speaking, in the past, a religious justification was never considered good enough. Certain very specific situations it was allowed. The draft, for example, you could be exempted from the draft if you had a religious objection to shooting people. But generally speaking, the law is the law, and we saw this. There's a wonderfully named case, Piggy Park Enterprises, which was when the Civil Rights Act of 1964 was first in place, and that, of course, banned racial discrimination in places of public accommodation, including restaurants. So this barbecue restaurant, Piggy Park, the owner claimed that his religion prohibited him from serving African Americans and white people together, and so he would continue to segregate his restaurant. The Supreme Court laughed him off. In fact, his religion claim was dismissed simply in a footnote. So that's how far we've gone on this. We've now got a situation where everyone from religious individuals up through churches, up through religious organizations such as Catholic Social Services here, and up to corporations are claiming that their religion exempts them from obeying the same laws that everyone else has to obey. If we look at the case itself here, the parties in the case, on the one hand, we've got the city of Philadelphia. And we all know the city of Philadelphia. I mean, this is not somebody I would look at taking on, I lived in Philadelphia. I used to sit up at the 700th level in Veterans Stadium where the Eagles fans would go crazy and things. On one hand. On the other hand, Philadelphia is a deeply religious city with a deep, deep history of various religions. My ex-wife was from Philadelphia, was Irish Catholic. And the first time I met her grandparents, I was introduced as not being a Catholic, and the response was that if I wasn't Catholic and I was in Philadelphia, I must be Jewish on that. Apparently there are some other people in Philadelphia now, but you've got Catholic Social Services, which does a lot of work in the foster care area with Philadelphia. They work with the city, and in fact, they have $28 million in contracts with the city regarding foster care. Despite what they say, what the religious groups are saying, this case isn't about Catholic Social Services being banned from participating in foster care. This case only applies to $2 million of the money. And what's it for? It's for screening potential parents. The first stage of the fostering process is parents come to these various agencies and say, we want to foster children. City of Philadelphia requires that they be examined on this, and they tell these private agencies to do that on their behalf. In March 2018, it became apparent through some newspaper articles that the Catholic Social Services were refusing to approve LGBTQ couples to be foster parents. And the city turned around and it was like, hey, no, you can't do that. We have a rule that says you cannot discriminate in this process. If you are doing this on behalf of the city, there can be no discrimination based on sexual orientation, and there's no exception to that. So that's the battle we're facing here. Like a lot of these cases, much of this is fought out in the media, and the media has been terrible on this. The media has allowed Catholic Social Services and the religious right supporting it to essentially lie about the background of this. I told you the first one, that this idea of they ignore the fact that $26 million in contracts are unaffected by this. There's the claim that we see time and time again that, oh, if religious groups are made to do this, well, they'll close down. I mean, that's simply not the case. The overwhelming majority of foster agencies in Philadelphia are religious. The overwhelming majority of them have found no problem with screening LGBTQ parents. There's also the argument that it's the children that are going to suffer on this, that, oh, if Catholic Social Services pulls out, then the children will suffer. That again isn't the case. There are plenty of agencies. The problem with fostering is that there aren't enough families who are approved to foster children. And so if anybody is reducing the possibility of kids getting fostered, it's Catholic Social Services, which is refusing to allow otherwise qualified LGBTQ parents to foster. There's also the claim that all LGBTQ people have to do is go to another agency. And that's true, but that's got a really unpleasant overtone to it. It's we're allowed to discriminate as much as we want, as long as you can find it somewhere else. We can refuse service to somebody on that basis. I don't think that portrays Catholic Social Services in a good light. It also ignores who the true victim is here. The victim is the parents who go in and who are refused to even start the process. And why are they refused? Because of their sexual orientation. That's the fundamental type of discrimination that our civil rights laws exist to prevent. It doesn't matter if you're an African American and there's a restaurant across the street where you can go and get barbecue. The barbecue restaurant cannot turn you down simply because you can go somewhere else. So what we've seen are these manipulations of the truth, and a lot of this comes down to it's the same old in the culture war battles about the LGBTQ community. And in particular, it was 2015 in Stewart versus Heinemann, the last state, Nebraska, had its law that banned LGBTQ people adopting and fostering. That law was overturned. So instead, they've looked for another method. They can no longer say you can't foster because the law doesn't allow it. Now they're looking for religious exemptions. So how do we get here? All the way to the Supreme Court. Getting to the Supreme Court is tough. The Supreme Court issues about 75 rulings a year. This is not an easy process. Anyway, what we've seen again in the media, time and time again, whether it was with Hobby Lobby or the contraception cases, the Notre Dame case, and we had nuns and our Sister of Mercy and all this. It's always portrayed in the media as the government, the nasty, mean government, coming and trying to force these good religious people to do things. It doesn't really fit in here when you look at it, because at every single stage, people have bent over backwards in this to try and accommodate Catholic social services, and they've refused to accept that. So, as I mentioned, a journalist turns up in March 2018 and has discovered that Catholic social services will not even interview LGBTQ families, couples for Catholic social services turned around and said, yeah, that's right, we're not going to do it, but you have to let us continue doing this. We demand an exemption. Philadelphia offered an accommodation in this. Philadelphia turned around and said, you can carry on doing this. You have to perform the function. You have to do the job and screen the people, but you can put in your report that you are not in any way endorsing or approving the notion of same-sex marriage or same-sex couples. Wasn't good enough for the Catholic group. Despite that, they went on. They sued in the district court. There was a 3-day evidentiary hearing in July 2018. And they turned around and said, this is not a violation of your constitutional rights. There is no discrimination against you for being religious. This is the requirement of getting the contract. You have to do it. So, of course, they appeal up to the Third Circuit Court of Appeals. In April 2019, a unanimous decision said, no, the district court was right. You're not being discriminated against. And now we're up to the Supreme Court. We've had oral arguments on this. We've had briefings. CFI submitted a brief with FFRF on this. And we had oral arguments. At every single level, Catholic Social Services has lost. But yet they're keeping on fighting. They obviously have very deep pockets on this. What they're trying to do is to maintain their own rules at the same time as taking public money. There's a danger here. There are just so many dangers of accommodating this kind of notion. The exemptions that are offered are never, ever considered enough. If you look at the contraception cases, the Notre Dame case, the government turned around and said to Catholic universities, to religious universities, you do not have to provide insurance that includes contraception. We'll do that for you. All you have to do is sign a piece of paper that says you don't want to do it. And so they sued all the way to the Supreme Court, claiming that signing that piece of paper was itself a violation of their religious rights. The intention here is that a religious group is wanting completely free reign. We've seen it. I mentioned the case of Our Lady of Guadalupe. It's like, if we want to fire somebody for having breast cancer, we can do it because the rules do not apply to us. And there's also a danger, and it's the notion that any parent fully understands here. And the Supreme Court has put this parental notion into effect, that if you provide a single exemption, and they made this in the Hobby Lobby decision, if you provide an exemption to one group, you then undermine your argument for not providing the same exemption to every other group that's out there. What is CSS arguing? Well, they made 4 claims. They claimed that this violates their free exercise of religion. They claimed it was a violation of the Establishment Clause that separates church and state. They claimed that this was compelling them to speak in a way that they disagreed with, that it compelled them to approve of same-sex marriage. And they also sued under a Pennsylvania law. Yeah, essentially all these come down to the first claim, the free exercise claim. The others are tacked on and are kind of ridiculous. What they're claiming, according to the Third Circuit, is they are seeking an injunction which would force the city to renew a public services contract with a particular private party with an exemption included in it. So they are saying that the court needs to put an injunction in place which says Philadelphia has to offer them a new contract and has to offer them a contract on their own terms. This is something that the Third Circuit, in classic judicial understatement, described as highly unusual. It's more than highly unusual. It is unheard of. You cannot dictate contractual terms in this way. In particular, they talk about how fostering and adoption services are something the church has historically done. And I agree with them. The church has historically been in there. I do think that's something that, in particular, the Catholic Church should be very careful of bringing up, because the history of the Catholic Church when it comes to child welfare is, let's be honest, not the greatest. We look at the stories coming out of Ireland. We look at the treatment of Native Americans with fostering and adoption in the United States, and the entire sex abuse scandals. The bottom line question here is, if the government is regulating something and is contracting that out to private parties, can they require you to do the job? We say yes. The Catholic Social Services says they are allowed to define what the job is themselves. What this comes down to in the end, and this is the battle of the Supreme Court, is the notion of what is religious freedom. And we're going to have to get a little bit historic on this when we're talking, because generally speaking, you go back to the Bill of Rights and the early government, the government really didn't impact your religious freedom a lot. What the First Amendment meant was they can't ban you going to church, to mosque, to synagogue. And everyone's pretty much in agreement on that, or at least I hope. But what we've seen is this growth of government interaction with individuals. And in particular, we saw a series of cases which were about unemployment insurance. Came down to Sherbert versus Werner. A textile worker was a Seventh-day Adventist whose Sabbath is a Saturday. And their shift was changed, such as they worked on Saturday, were required to work on Saturday. They refused. They were fired. As a result, they claimed unemployment benefit and were initially rejected on unemployment benefit because it was voluntary unemployment. They sued, it went all the way to the Supreme Court. The Supreme Court said no, they're entitled to unemployment benefit because they shouldn't be required to abandon their religion in this way. We then saw 1990 Employment Division versus Smith, which is a critical case for this entire area of law, and particularly this case. This was similar. This was a Native American in Oregon who was fired from his position for using peyote as part of a religious ceremony, but he was fired from it because peyote was illegal. And he applied for unemployment and was refused it. And so it went all the way to the Supreme Court, and the Supreme Court turned around and said, no, you don't get it. And the reason you don't get it is because laws, if a law is general applicability, it applies to everyone, you don't get an exemption just because you're religious. And this, according to religious groups, was the craziest thing they'd ever heard. This was earth-shattering. It was put into place by that hard left-wing radical Justice Scalia, who wrote the decision in Employment Division versus Smith. And as a result, Congress then passed the Religious Freedom Restoration Act in 1993. Don't want to get too tied down on RFRA at the moment because I could talk all night just on that. But essentially what Employment Division versus Smith says is that if a law is neutral and it then applies to everyone in the country equally, you do not have an opt-out clause from being religious. So what's the claim here? The claim then is this idea of neutrality. Catholic Social Services says the requirement to certify LGBTQ parents isn't neutral. To me, it seems neutral because everyone has to do it, but let's look at what this idea of neutrality actually means. Well, Smith itself talked about this. Justice Scalia gave an example of a law that wouldn't be considered neutral, and that was, for example, a law that banned worshipping a golden idol would clearly not be neutral. Obviously, the Congress does not pass a lot of laws restricting your right to kneel in prayer to an idol. But what we saw then was the case of we have the best, church-state law has these great case names. So this one, Church of the Lukumi Babalu Ai Incorporated versus City of Hialeah. City of Hialeah in Florida. Church of the Lukumi Babalu Ai was a Santeria church, which is this Haitian religion that developed as a mixture between indigenous religions and African religions and Catholicism. But the city of Hialeah hated the church. They just didn't want it there. So they passed a law against slaughtering of animals. And they then turned around and made it so clear that it was directed against this church because they exempted absolutely everybody else. So the Jewish and Islamic communities went and said, but we're allowed to slaughter animals, aren't we? And they were like, yeah, of course you are. We're not, this law isn't about you. So that was considered a non-neutral law. And then more recently, we saw Masterpiece Cake Shop, which I'm sure you all remember, the baker out in Colorado who refused to bake a wedding cake for a same-sex couple. He's currently back in trouble for refusing to bake a gender reveal cake, a gender transition cake for a transgender person. And this was decided to be not neutral towards religion because of comments that were made during the hearing. And for example, if I could just dig up the big problematic one, supposedly, was when one of the commissioners turned around and said, freedom of religion and religion have been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use, to use their religion to hurt others. This was determined by the Supreme Court to show enough hostility towards religion that it is no longer neutral. There's a problem for me for that, because that statement is absolutely factually correct. Religion was used to justify slavery. Religion was used to justify the Holocaust. Religion was used to justify Jim Crow, to justify marital rape. So many things. And apparently saying something factual like that is now considered to be hostility towards religion. For example, the comments I made earlier about the Catholic Church's history with child abuse would presumably eliminate me from being able to render any verdict on this case. It's trying to tilt the balance in favor of religion. But neutrality, according to the Supreme Court, means this. It asks whether challengers have been treated worse than others who engaged in similar conduct because of their religious character. Here, that simply doesn't apply. Why doesn't it apply? Well, the Catholic Social Services were asked to do something that every other group, regardless of their religious nature, was required to do. To me, that's the classic neutral law. But they claim lack of neutrality in various ways. Firstly, they talk about some comments made in the process. And one of the Philadelphia officials turned around and said, it would be nice if you followed Pope Francis's teaching on this. That supposedly is now sufficient to show hostility here. When the city was investigating this, they called around other adoption agencies to find out if anyone else had a problem, and only called religious agencies. They actually called one non-religious agency as well. But of course they only called other religious agencies because the claim itself was one for a religious exemption. And they then found out that no other religious group had a problem with doing this. Catholic Social Services claim that this is hostile to them because they're not allowed simply to refer the people to another agency. They have to evaluate them. This, again, I mentioned this before, this is the whole separate but equal concept that I really thought we'd put behind us. And finally, they claimed that it's not neutral as regards religion because the city considers a child's race, a child and a parent's race and their disability status in making these decisions. This is a real Hail Mary on their part because they do this when they're considering where to place a child based on the best interests of that child. And they say the only time it's actually really come into effect is, for example, when you had a child who was known to use racial slurs. They didn't place that child with parents of the race that the child was known to repeatedly slur. So what can happen here? What outcomes can we get? Well, City of Philadelphia can win. We can win. I initially said this was impossible, but it's not impossible. Nothing's impossible. And I read back through oral arguments again, and I can kind of plot a path for victory. It's kind of like on election night where you manage to convince yourself that, yes, if the Democrats carry Missouri and somehow Utah votes Democrat, the Democrat can win. It would be a huge upset if we win this case. We've pretty much planned to lose because what they would need to find is that firstly, this is a contract, and so the government's allowed to put on pretty much whatever rules it is, and that there's no religious discrimination in it. It's a neutral law, it applies to everyone, so there's no exception. I guarantee I'm getting 3 votes for that. Justice Breyer will vote for that, Justice Sotomayor will vote for that, Justice Kagan will vote for that. I then need, for that to happen, I need to get 2 out of Chief Justice Roberts, Justice Kavanaugh, and Justice Gorsuch, and that's tough. I don't think this is going to happen. If I was a betting man, and indeed I am a betting man, I would give it maybe a 2 or 3% chance, if even that. So realistically, it looks like Catholic Social Services wins, but then the question shifts to how do they win? Oddly enough, perhaps the best way we can see them winning is if the Supreme Court says that there was sufficient religious discrimination that this wasn't neutral, that these comments made about Pope Francis shows that there was hostility towards religion. Why would that be the best possible loss? Well, because it doesn't actually change the law if that happens. It would be wrong. It would be an unreasonable definition of lack of neutrality, but it might be the best way. The other alternative is they turn around and said, yeah, this is a neutral law, but we don't care. That we are reversing this decision, Employment Division versus Smith, and we are saying that you have a constitutional right to an exemption from a neutral law. That's a terrifying possibility. And what I want to finish on is looking at the impact if that happens. What this would mean is that every single government contract would have to include an opt-out clause for every religious group that claimed any kind of exemption. on this. It would be a disaster. I don't work in government contracting. I'm glad I don't. And if this goes through, I don't think anyone else is going to take that job either. The reason that they brought this case as they did is because it's to do with the LGBTQ community. And there's still this notion out there that religious discrimination against gay people is kind of okay. It's seen as tolerable in a way that religious discrimination against people based on their skin color simply isn't. And we saw this through the entire arguments at the Supreme Court. Time and time again, they were saying, well, what about if they won't do Black couples or interracial couples? And time again, they said, well, the government interest in protecting against religious discrimination is way more important. That's actually not really what's going on. And it's unfortunate because what we're going to see here is if this goes through, it's going to allow all sorts of discrimination. We've already got adoption agencies and fostering agencies who are requiring the parents they work with to share their faith. So we're going to see, can Catholic Social Services refuse a Jewish family, a Muslim family, an atheist family on this? There's also, it would be a huge redefinition of this notion of religious freedom. This idea that religious freedom allows you to disobey the laws regardless of who else gets hurt is just one that is a fundamental change here, and to me undermines the entire notion of secular government. Our basis of our government is that your rights do not depend on your religion. That's something which it's the notion is what made America unique at the time. And it's something which they are looking at casting away for this incredibly, incredibly broad sense there. So there's a lot at stake here. If we lose Smith, we are edging ever closer to a theocracy, to the notion that a religion gives you an opt-out from obeying the rules. Now, currently, the Supreme Court is willing to say, well, any religion. It's not just Christianity. It's any religion will do this. And of course, that discriminates against us, the non-religious. But it's not going to end there. And we've already seen this. The more minority your religion is, the less rights the court is willing to enforce. Look at the Trump Muslim ban on this. The Supreme Court was willing to allow the Muslim ban to go ahead. Can you imagine they would have made that kind of decision if it had been Christianity that had been restricting entrance of Christians? What we'll see first is this will require government to favor religion in general, and then as it moves down, it will be favoring Judeo-Christian, because that's the term they always use. And we sure know when they talk about Judeo-Christian, which half of that phrase they're talking about. There's an incredibly large amount of stake in this, and I am more than happy to answer any questions which I'm capable of answering.
Great, thank you, Nick. We do have a few questions, and I have a few questions as well. I'm going to just start with a pretty straightforward one. Richard was curious who has filed amicus briefs alongside for the Fulton case. I guess I assume he means against,
on our side.
Yeah, on our side.
Pretty much the usual suspects on this, and you've seen lined up on both sides. CFI, FFRF, and American Humanists filed one brief. Normally, American Atheists would sign on to that one. They wanted to do their own brief on actually what I think of as it's a genuinely interesting point, and I wish we'd written it, which is that there's a huge free speech question here. are we now going to say that elected officials and government appointees cannot criticize religion? There's a major free speech issue there. The ACLU didn't do an amicus brief because they're the lawyers on the case. All of the general pro-church state groups did this. A lot of the progressive groups. The best way to find out who does it, and I apologize, I don't have the list here, either go to the ACLU page on the case or go to SCOTUS blog on the case, and there'll be a list of everyone who filed amicus briefs.
Great, thank you. And you actually already started answering this question. I think you did kind of answer, but I think it might be good to explain again and how it fits into the bigger picture. Betsy was asking about, I think she's asking about the Zubik case, about the accommodation that the administration offered to file fill out a form to say that they objected to the contraception. And so her question was, basically, how can you help us understand this? They claim that it was, what did they mean when they say that the filing the paperwork was burdensome?
Yeah, interesting. How can I help you understand it? I can't, because this is not understandable. It goes back to something that Justice Alito did in Hobby Lobby that is going to haunt us on this. It's this notion that if a religious group claims something, it can't be challenged because otherwise the court would be looking into the internal authenticity of a religious belief. So this is in particular a problem for CFI because of the scientific integrity part of our mission. In Hobby Lobby, they objected to certain forms of contraception, such as IUDs and emergency contraception, because they claimed they were abortifacients, that they caused abortions. Here's the thing, they don't. That is factually incorrect. This isn't up for argument. This is a straight definitional point. They don't. But you can't turn around and say, you can't challenge that, according to Alito. And the example I tend to use on this, it's kind of out there, but if a school district required that all of its students ate a bacon sandwich, a Jewish group would have a perfect court case against them. Clearly, that's religious discrimination on this. But if the requirement was that everyone ate a turkey sandwich, the Jewish group couldn't turn around and say, well, no, we're going to interpret that as being a bacon sandwich, so we're going to refuse to allow it. That's the problem on this, and it's never been accepted in the past that simply saying, I want to take advantage of an accommodation, putting your hand in the air, that itself is imposing on your religion. Look at the notion of the draft. You can get a religious exemption to the draft, but you have to ask for it. You can't just not turn up and claim that your religion prevents you even from asking for an exemption, because I can make a pretty good argument on that. If you look at that, if I ask for an exemption and you give it to me, they're just going to get someone else to go in my place. So the end result is the same. But we've never said I have the right to prevent anyone being sent. It's I have the right as a religious person not to be drafted. Fortunately, the Supreme Court never got to say that signing this paper was itself a burden, because the case went away because Trump won the election. But yeah, this is where we are in the law now. We are at an area where we are saying that putting a paragraph in saying, I don't agree with these couples isn't enough, because you are allowed to define what the imposition is.
And I think similar to what you said about the draft example of saying, well, by me telling you that me requesting the accommodation, someone else can be replaced. My understanding in Zubik was that they were arguing, well, if we request this accommodation, then the employees will be provided with birth control by someone else. We just don't want them to have access to birth control, and we're triggering that process, and that's where it goes too far, similar to your draft example.
Absolutely, absolutely. And our argument is, yeah, you know what, you are, but it ain't your business. You know, you may have the right not to pay for it. You don't have the right to prevent a woman from getting it.
Right, exactly. So here's a question from Alyssa, and I have a feeling I know the answer, and it's not going to be very positive. But she was asking, you know, Philly is in this case, if all the previous appeals have gone our way, why is the chance of the Supreme Court winning in our favor so low?
Multiple reasons. I mean, the first reason is if we look at how the circuit courts are made up. Of course, judges are officially politically neutral, but they're appointed through a political process. And that process allows, there's a reason the Ninth Circuit, which covers California and the West Coast, the Third Circuit, which covers Pennsylvania, Delaware, the Second Circuit and First Circuit, which are New York and then New England generally, tend to be more liberal on this. This happened in Philadelphia. The Third Circuit is a very good circuit for us on church-state separation. Had this been coming out of Alabama, we would have lost at the Fifth Circuit. It would never have happened in Alabama because ain't no city in Alabama having a law that says this in the first place. So that's one reason. Also, second reason is, you know, the Supreme Court is packed. And the Supreme Court, and this isn't a partisan thing at all. There have been great Supreme Court justices appointed by Republicans, appointed by Democrats. It's not a partisan thing. What we have seen is a packing of the Supreme Court with people with a Christian nationalist interpretation of the Constitution. For that reason, Trump is going to go down as the religious right's greatest ever president because he managed to change the federal court system so much. And if you read the oral arguments, which is where I came out with the 2 to 3%, I can see a way that Gorsuch or Kavanaugh and Roberts go over. It's just very, very unlikely.
Okay. So here's another question from Glenn, and I'm going to kind of broaden it a little bit. He says, if the case comes out not on our side, is there a way to try something is there a way to show how absurd the ruling is that the Supreme Court might reconsider, which I imagine would be maybe another challenge, you know, as the questions come out. And I'm going to broaden that to sort of just the what do we do question of, well, if this is the kind of thing that's going to be brought to the Supreme Court and not be ruled in our favor, where does that leave us in terms of how we can reverse the damage? Is it really just waiting until there are Supreme Court vacancies? Is there legislative advocacy we could do, regulatory, anything?
The Supreme Court is thought of as this body that decides things purely on the law. That's just not the case. The Supreme Court holds its finger to the wind. There is a reason the Supreme Court determined in a period of about 20 years, went from Bowers versus Hardwick, which said states are allowed to criminalize same-sex relationships, to Lawrence versus Texas, which said you can no longer criminalize this, to Obergefell, which said all 50 states must allow same-sex marriage. And the reason was that public opinion shifted dramatically during that time frame. The work that groups do to normalize the non-religious and the secular as well. And I think the allies, the non-religious and the secular communities are separate, but should be allied very closely on this. I have no problem with fighting alongside people of any religious views, that as long as they believe in a secular government, willing and fighting that. How do we do this if we lose? This one is tough, because if we, I mean, we can lose this in nightmare fashion, but even if we lose, I guess we could have people applying for, it's the flying spaghetti monster, the Satanist tactic. You know, you teach them that if they want to start giving exemptions to religions, you've got to give it to everyone. What I worry about that as a strategy is, does the Supreme Court then start deciding what are religions and what aren't? They've already turned around in a prisoner case out Nebraska, I think, and said that Pastafarianism is not a religion that needs to be respected in the jail system. So I love what the Church of Satan does, and I think they're just good people generally. I am worried that we're going to start to, that the court is going to accelerate it. Well, when we talk about religion, we really mean people who go to church, temple, mosque, whatever, however they're going to define it. So I don't know what we do. I hope we can do something. You could give me money would work, Glenn. That would be fantastic.
Yeah, 2 minutes left. So I wanted to ask you specifically about how this.
I'm sorry, I lost you there.
With the passage of the Act.
The passage of the Equality Act?
Remedy decisions in this.
I did not get any of that, Sarah, and I'm sorry.
You froze, and I wasn't sure if it was me or you, so I'll just repeat the question.
Yeah.
So the question was, how could the outcome, the various outcomes that could come out of this case, how do they relate to the Equality Act and the Do No Harm Act? What impact could the passage of those bills have on this case, or would they be totally, if we had
It depends how they decide it. If they overturn Smith, and if they say there is a First Amendment constitutional right to a religious-based exemption, and they take that through Hobby Lobby and things to apply to for-profit corporations, to me, that chops the Equality Act and the Do No Harm Act at the knees, because it'll turn around and say, yes, it is federally prohibited to discriminate based on someone's sexual orientation, but we have to give you an exemption to that if you claim it's religious. And honestly, pretty much all discrimination against the LGBTQ community comes from a religious basis. What is fascinating on that as well, sorry to slightly off on a tangent, is what this is saying, how people can claim this is constitutional if they're turning around and saying being anti-gay is acceptable if you're religious. It's constitutionally protected if you're religious, but not if you're not religious. How is that not violating the Establishment Clause by privileging religious views over other views? This is why I'm not on the Supreme Court. Well, also the fact that I'm British as well. But
so you said you walked us through the worst case scenario. So what would be a sort of, we lost, but it hasn't nullified, that the Do No Harm Act and Equality Act could still have impact?
If they make a decision which is saying essentially that Philadelphia was mean and only did this to pick on CSS, then what we need to do in the future is be incredibly careful what we say when we're writing laws, what we say in any kind of legislative hearing, because any word that could be construed as being anti-religious would show that it was no longer neutral. To me, that's a ridiculous way of governing. Something's either neutral or it's not neutral, but that's what we need to do. If they turn around and say, now, just like Masterpiece Cake Shop, stop being mean to the nice Catholics, then we have to make sure in public we are overwhelming in our complimenting the church for the wonderful job it's done throughout the history in placing foster children and placing adoption children. However, we have a compelling interest in ensuring that the LGBT community is not discriminated against, and that there are enough parents for us to place people with. So therefore, we fully respect your religious beliefs on this matter, but it is therefore of critical importance to us as the government to prevent discrimination. Just has to change the way we're talking about it.
Okay, and that would be a case where they would rule in favor of the plaintiff just in this case, but wouldn't change what neutrality means at large.
Yes.
Therefore, Do No Harm Act and Equality Act in that scenario, although not ideal, would still have impact.
Not ideal, but they would still have effect, and we'll be back in a year's time with another Supreme Court case looking for another religious exemption from another civil rights law. We need to turn around. I love the Do No Harm Act, but the Do No Harm Act needs to be recognized as part of the Constitution, in that you don't get an exemption if it harms third parties. This is the way it always used to be. The Constitution was always interpreted before. The Do No Harm Act should not be necessary. Unfortunately, it is necessary.
Right. Well, we are just past the hour now, and we really appreciate your time here and going through this, the different scenarios, so we know what to expect. Now, there's going to be, is this typically going to come out in June? Is that right? When are we going to expect a decision?
Well, put it this way. I just got an email today from Alison Gill over at American Atheist, which is like, hey, do you want to do an online panel on the decision the day after the decision? And I'm like, yeah. And she goes, well, let's assume it's not this week. It may well be next week. So this could come out on Thursday. I'm not certain it will. And we're going to know immediately what the verdict is based on who wrote the opinion. Right.
Okay, well then, if you all who are tuning in are not already, you'll get that breaking news from some of these great secular organizations that we're in coalition with, who are on this. So Center for Inquiry, American Atheists, American Humanist Association. This was a really timely discussion. So thank you again, Nick, for informing us. I'll just close by in a minute throwing in the chat the volunteer form to sign up for Jews for a Secular Democracy. This kind of issue is exactly why we have to do a lot more education and advocacy around church-state separation issues. And I think this is a great example. This is something that you can really use when you're talking to interfaith allies, elected officials, other decision makers, because you can imagine, as Nick mentioned, how this kind of issue would impact Jewish couples who might want to adopt or foster children. And in fact, that has happened under the Trump administration, that there was a foster care agency in South Carolina that got a waiver to allow against not just a Jewish person, but also other non-evangelical people who are applying for that program. So this does impact the Jewish community. It's a great example of why we need church-state separation. So thank you so much to everyone for joining us. Thank you, Nick, and stay tuned.
Thank you.
Good night, everyone.